Today, we're going to learn about discipline of legal practitioners. So, legal practitioners have three disciplinary bodies or authorities that exercise this power over them. First, you have the LPDC, so the Legal Practitioners Disciplinary Committee, which is a committee of the body of benches. And then we also have the Supreme Court as a disciplinary body over legal practitioners. And finally, the Chief Justice of Offense or Conduct. Could a legal practitioner be disciplined by either one of these bodies? Now, the first we have is for infamous conduct in a professional capacity. Now, what does this mean? That the conduct is infamous. The conduct is infamous if it is something which would be regarded as disgraceful and dishonorable by professionals of good repute. So something which a legal practitioner does, which other legal practitioners would consider as being dishonorable, all right, in the line of their work. For instance, misappropriation of clients' monies. All right, if a legal practitioner should misappropriate monies which he's received on behalf of his client, that's something which other legal practitioners of good repute would consider to be disgraceful. So that's infamous conduct in a professional respect. So it's something that is connected with his professional work. Now, the second we have is conviction for an offense which in the opinion of the LPDC is incompatible with the status of a legal practitioner. And so if the legal practitioner is convicted for an offense which would be considered to be incompatible. So this time it's about engaging in some kind of conduct which would not be dignifying to the legal profession generally. For instance, if a legal practitioner is found fighting the public, or someone who's maybe habitually drunk and is found maybe laying in a gutter somewhere, very occasionally, this is the sort of thing that would bring disrespect and dishonor to the profession. Now, the third we have is obtaining enrollment by fraud. So if a legal practitioner, for instance, has had to falsify any records or documents in order to secure enrollment, and this is not just talking about the enrollment that takes place at the Supreme Court after the court of the bar ceremony, even if the person has falsified, records at a much earlier stage, maybe to gain admission to Nigerian law school or even to their law faculty, this would be enrollment by fraud. Now, the fourth we have is conviction by a court in Nigeria of an offense which is incompatible with the status of a legal practitioner. So this time, if the person has been charged to the court, to of course our civil courts, and has been tried for an offense for which they've been convicted, and that offense is one which is incompatible with his status. So it's not a minor offense. For instance, let's say just a misdemeanor, a minor driving offense, for instance, would not be something so serious. But if a legal practitioner, for instance, is convicted of an offense like maybe assault, maybe murder, then surely that would be incompatible with his status. Now, you see that if a legal practitioner has been convicted of any of these offenses, and the punishments that could be imposed on him are as follows. One, the chief registrar may be ordered to strike out his name from the roll. Okay, two is that he could also be suspended from practice. And three is if it's not something that is so serious, he simply may just be admonished. Now, if there has been misappropriation of monies belonging to the client, the legal practitioner may also simply be ordered to return such monies or documents to the client. Now, you see that after a legal practitioner has been convicted, it's possible that the legal practitioner whose name possibly has been struck out of the roll could have his name restored to the roll. Now, in what circumstances would this be possible? Section 14 of the Legal Practitioners Act tells us that for restoration of the roll to take place, there are certain conditions that will be considered by the Supreme Court or whatever relevant body there is considering it. One is the gravity of the offense. All right, so how serious was the offense he committed? Two is sufficient evidence of genuine remorse. So has the legal practitioner in question showed any true remorse for the offense he committed in the past? And three is that he must have become a fit and proper person. So is he now, behaved in a better manner? And four is the length of time that has lapsed since suspension or striking off of his name. So how much time has passed since he was punished? Has he, suffered enough for what he did? So these are the things that will be considered, and then his name may be restored to the role. So thank you again for learning something new with me today, and I'll see you again.